Hi again, and welcome to Beyond the Gavel. This is the podcast that ventures deep into the intricate world of personal injury and medical negligence litigation. And I use it to explore the insights and experiences for some of the most distinguished voices in the law today. And I'm your host, Rodney Peyton. Today, I am privileged to welcome John Browne, partner at Hussey Fraser Solicitors in Dublin. He's renowned for his extensive experience in catastrophic injury and complex medical negligence cases, and he's earned a formidable reputation for his meticulous approach and his unwavering commitment to justice. His insights have not only shaped landmark judgments, but have also influenced practice across Ireland and even beyond. So today, join us as we look into John's unique perspective on navigating high-stakes litigation, client advocacy, and the ever-evolving legal landscape in medical negligence. So, John, let me welcome you to the programme. Thank you so much for coming on today.
Delighted to be here. Thank you, Rodney.
You're very welcome. John, I think our listeners would like to hear first, your background. Everybody has a unique background on how they got into this. How did you get into the law and then into medical negligence and personal injury?
So, when I left school, I was a talented soccer player. So, my plan was, because I was being scouted by a lot of clubs in the UK, my plan was to try and get signed by a team and to go to England to play football professionally, essentially. But I had an interest in law, and I sort of made a plan that I'm going to give it another 12 months because I had so many clubs watching me and sort of promises of this and that. It didn't actually result in a formal commitment. But I said I'm going to give it another 12 months, and if I don't get signed, I'm going to go and study law. I actually watched a movie, I remember it, as a teenager, Paul Newman, The Verdict. And it's about a plaintiff malpractice lawyer, actually in Boston. And that was actually what inspired me to go into the law. And I just went from there. I gave it that 12 months and then I went to university to study law.
Do you regret that?
No, no, I don't. No, I don't.
So what attracted you to the law as a thing in the first place? It's interesting. People second. I mean, we've been with Bocelli recently, and he was a lawyer before he became a well-known singer. He trained, at
That's
least he
right.
trained in the law
That's
first.
right.
So it seems to be a path that some people do at different guises. So what took you into the law?
But I had personal experience, and I saw people and family members that were sort of victims of injustices. And, if they didn't have access to legal people, they weren't going to be able to do anything about that. And I suppose it was a sense of seeking justice, to be able to get to justice.
So that's where that unwavering commitment came from, that
Yeah.
you'd personal experience, and that's really it was your personal experience that brought you into it. Is that right?
Yeah, a little bit, yeah. Just a few things with family members and that's
And
what.
was that to do with medical negligence type things, or just other
Yeah, one
aspects?
was. One personally was. Yeah, I had a bad injury from sports, and I was left with that injury for about 8 years until I got a second opinion, and the second surgeon was astonished that I was told that, and he redid it, and then everything was fixed from there.
So it really became very personal for you.
Yes, yeah, little. It gave me a great insight, I suppose. If you're an athlete, you get to know injuries and the body because you have to be very in tune with all that. And whether you like it or not, you're going to see a lot of physiotherapists and medical people. So that gave me a good background to combine with personal injury and medical negligence to a degree because you get to know the ins and outs of the medical side a bit before you actually get into practicing law.
And did you have any involvement with the law before that, or before you decided the medical negligence claim? Had you asked other people in the law before this came up, or not? Or is it just it went medicine first, then the law?
Yes. So when I did my apprenticeship would have taken me up to the start of the millennium, a couple of years, and that was general practice. So everything essentially, a general practice firm in the city centre of Dublin, across from the Four Courts. And then when we went to Blackwell Place where we trained, you have to sit beside the same person every day. You're assigned a seat on the basis of your surname, whatever letter. so my case B. And I liked the idea of personal injury from the personal injury cases I had done in general practice. And a friend of mine there tipped me off about a firm that was looking for new solicitors, and I applied and I started off there.
So the relationship was important. Somebody who knew you, obviously they were putting themselves in line, but who knew you suggested you do this. Is that right?
That's exactly it. So then
There's something to do with relationships that you build up on your way through, isn't it?
It's very important, absolutely. And that person who used to sit beside me tipped me off about a personal injury solicitors firm that was looking for new lawyers, John Browne Associates, and I started off there as a personal injury lawyer and a medical negligence lawyer, working in a more junior role, assisting other medical negligence lawyers.
Did you have good mentorship there?
I did, very good. My general practice office was a sole practitioner, so it was very hands-on and it was intense because you don't have the backup. And then when I went to that firm in 2000, John Browne Associates, it was a very structured, organised firm, good mentors, good systems. John himself was a great personal injury lawyer in his day, a great medical negligence lawyer, and he had written books, so and they were very good for people who wanted to study law in that area. So it was very structured. So I got a great 3.5 years of experience in that firm.
So what do you say? I mean, a lot of young people now, they don't want to put in the time, that maybe that's true, but I don't know anybody that's made it that works 9 to 5 Monday to Friday. I just don't know anybody that's made it to any extent. But I get the impression some of people coming through expect to sign on and sign off. What's your advice to them? What has been your experience, and what is your advice to those who want to make it, not just be your average lawyer, but who want to really make it and make an impression? What would be your advice to them, these young people coming through?
My advice would be you need to want to do the area of law you get into. You want to work in that area, and you need to work beyond 9 to 5. You need to expand your bubble if you want to do well. You need to be able
It's
to
very
do
interesting.
beyond.
Talking to you're in sport through some of the people I work with. Speaking to a very famous coach in the United States who's known to stand on the sideline and literally scream in basketball, scream at the players in college basketball. And they put him aside and said, look, why do you do that? Because actually the players loved him. And the answer was, when a player comes to play college basketball for me, I say to them, listen, what is it you want in life? And I said, well, I'd like to maybe follow the basketball and then I have to have this secondary stream and I'd want to work just like you did, your soccer and your academia. And he said, so what do you want from me? And they said, well, you're a coach and your guidance. And said, so you want me to coach and mentor you to be the best version of you can be? And they said, yeah. He said, so whatever I do, if it's to do with making you the best you can be, should it be on the court or should it be in your studies? You're all right with that? And they said, yes. And he said, I do that first. And when I get that agreement for them, I can scream and yell when I need to. And I do it when I need to. But because that's what they dedicated themselves to. Whereas people who just want to be average and left alone, they're going nowhere. So what do you find in people coming through your practice? How do you select people that you will take on in your practice to train and to mentor? Because I know you do a lot of that.
Well, what we're looking for is something you touched on earlier. We're looking for people as to why do they want to get into law. For example, if someone wants to get in for the prestige, then that's not something that we're interested in. If someone wants to get in because they think law is a way, something you can make quick money in or good money easily, then it's not someone we're interested in. We want people who are interested in their cases and their clients. So we're looking for personal injury lawyers or medical negligence lawyers who will do the work that clients need to achieve the results for clients.
Work on behalf, be a servant leader or a servant lawyer. There's, not just taking it, but be a servant to the people who come in over your door.
Absolutely. Very important.
Those
Very
clients through.
important. Very important. You
Yeah.
have to listen to your client's story. It's very important. You shouldn't prejudge them. You should listen, think laterally about the story they bring to you. Also very important not to be taken in by the story and consumed by it, because you have to have empathy, but you need to apply your knowledge and give advice to your clients quickly. No matter how much empathy you have, of course you need to give them extra advice.
Yeah, and you can't get emotionally involved with them, sympathetic wise, but empathy. You got to listen to understand, isn't that right? Instead of listen to reply.
Absolutely.
All
Absolutely.
forms of life, that is. So great insight there into how you deal with that. And how do you manage client expectation? I mean, given that, and you are empathetic, what do you say to your people about how you manage a client's expectation?
Expectations is actually something that should be dealt with in stages. So particularly for a medical negligence lawyer, the starting point of a case is establishing breach of duty, liability and causation, and that takes a considerable period of time, perhaps the first year of a case for a medical negligence lawyer. So expectations about damages shouldn't really be addressed at the start of a case. It shouldn't be addressed until close to the end of the case. I find that most clients that we deal with as medical negligence lawyers are not that focused on damages or quantum. They're focused more on what's happened to them, how to get better from that, and to know that they have a right of remedy. Do they have a sustainable case? That's how I manage expectations, and we have a team, of course.
Mm-hmm.
We also have counsel, two barristers normally in a case, and we often discuss expectations and quantum towards the end of the case. It's also not possible to advise a client properly in the early stages of a case in relation to quantum. So expectations can only be clear when the values are clear. And that's quite a while into a case.
Yeah. Now we all know that a lot of people that walk in over your door, it's complaints they have. Some of them want to know what's happened. They want to make a complaint, and the complaint's not the same as a case in medical negligence. So in that initial phase, how do you decide whether you're going to make a client a plaintiff or not? I mean, do you take on all comers, or how do you sift out what you're going to take and what you're not going to take?
So we very quickly decide whether we will open a case or not, and we will advise the client as properly and politely as possible. If it's a complaint, then we advise the client to take that up with the CEO or complaints department at the appropriate hospital or patient liaison body. And we explain why that is the case, and that it's not a case that we can pursue through the courts. The courts do not provide a remedy for that type of situation if it's only a medical complaint, and they don't provide damages for it. And there isn't actually a forum available to.
Yeah. And when do you start getting medical opinions? What do you do about that?
We take up our clients' medical records. Some clients will come to us with their medical records, but as medical negligence lawyers, we will write to the client, get their written permission to take up their medical records. And once we have all of the records that we need, then we will seek an opinion from a medical practitioner. We can discuss.
Do you use screening at all?
We do use screening, yeah, we do. We often get limited records from a client in very sad, tragic cases where someone has died. We will get the autopsy report or post-mortem report to provide a preliminary opinion. So we do screen cases.
And what's the advantage of that to your client or to your firm?
The advantage to screening cases is it gives the client a quick response on their query, and it, for our firm's point of view, it reduces our outlay on the case in terms of time, cost and expenditure.
Yeah, and also the effort, I suppose, that your staff have to put into it.
Absolutely.
And the constant phone calls in my case come up yet. I talked to you last week,
Yes.
we've all been in that one.
Yes.
So what challenges do you see at the way things are going at the moment with running these cases?
Well, the Irish legal system evolves over time. I mean, it's different to when I started. New rules come in, new changes come in. all sorts of challenges. Every now and then a judgment pops up that might impact on a particular area of medical negligence law, which will represent a challenge for medical negligence lawyers.
Any specific thing come to mind? Not obviously talking about a particular case, but specific, situation came to mind where you find that, the law really was rather grey in the area.
Well, at the moment there's a case which is ongoing, which has been published. So it's an open case called Germain versus Day, which relates to the law of nervous shock in the Irish legal system. And this is a published judgment. It's not a client of ours.
Yeah.
And it has certainly created debate in the legal community about the exact nature of nervous shock, more so not for patients, but for the immediate family members of a patient who may be subject to a personal injury or a medical negligence injury, and as to whether or not those family members have a right to claim for damages. And a whole series of tests have been set down for that, many of which go back 30 years across various judgments. So it certainly has created a lot of debate across the Irish legal community from medical negligence lawyers in particular, with varying opinions as to whether the nature or the true impact of that on the ability of the plaintiff to bring a claim.
Yeah, it's in the UK too. It's all about proximity. I mean, they've really defined it. I mean, if you end up in hospital in the same condition as you were when you were hitting the road and your relative sees you, that's fine. But if it's later on and you've been tidied up, it's different. On whether you were, the loving connection, the proximity, all that sort of thing. Is that the stuff that they're talking about now?
Yes, they're talking about proximity, of course. Which is relevant when you're dealing with a loved one. Are you even in the country when it happened? Things like that. Duty of care. Who does that duty of care extend to? And that's fact-based, essentially, on a case-by-case basis. So for medical negligence lawyers, the individual facts of your case for your plaintiff are so important.
Yeah. Oh, absolutely.
You need to apply that to the test set down in that judgment. That's so important for plaintiff lawyers to really.
Well, it's very interesting the way that's coming up, because rather like Montgomery affected Ireland, after the fact. I mean, these changes are occurring and becoming more defined in what's accepted and what's not accepted.
That's right.
So it evolves, which shows the importance of CPD for lawyers, as it is for doctors, obviously, because medicine changes all the time. And it never stays the same. So we discuss now something that happened 20 years ago. It's a bit of a problem because medicine has evolved. And you're finding the legal system is also evolving, and you've been part of that evolution. So tell me then, in the future, if you were, you're teaching these young lawyers coming through and things, and if you were to give them one piece of advice from your extensive experience that would help them in these complex cases to be successful in what they're going to do, what would that advice be?
The first thing I would say is that you must have empathy. If you don't have empathy, you shouldn't be doing those types of cases. Clients have said it to me. Some have sent me emails and they say, "You're the only person that listens to me." So they do want to be listened to. You need to listen to their story. You need to consider that story and don't prejudge them. Listen carefully. Think laterally about their story in a legal sense. Can you do something for them? Then you need to be honest with them, and you need to deliver that message with empathy. So
it's that honesty and integrity, isn't it? I mean,
that's
both sides.
It is key. It is key.
And what about relationships with people? I mean, I think you brought up in the beginning of how that relationship helped to form you and when you went into that. I mean, there's an old story, a good lawyer has a relationship with a client, an excellent lawyer has a relationship with a court. And it's the people you know and who know you, and it's about your reputation. What do you tell them about their reputation?
Well, it's very important to do your business properly, be very clear and honest with your colleagues, other lawyers. Then they get to know your reputation over time. They know how you work. They become comfortable with that. It makes your life easier because many agreements are made verbally between lawyers. Moving cases, adjourning cases. Most of it's done on correspondence, but not everything has to be. So your reputation is so important. It's so important.
And it's not really what you think of yourself, it's what other people think of you when you're not there, isn't that right?
Absolutely, and then they know that your case will have merit if you brought it, because they know the type of cases you bring.
Exactly. And I think that's very important. And it's not only you go into court, but if you bring experts into court or you take a particular counsel, the court very soon get an idea about you with whom you put up in front of them, what sort of evidence you put, what your counsel does, and because it's the people you select that run into the court. And
Absolutely.
it doesn't take long for the bench to start to understand who you are, what you are, and whether you are who you say you are. It's all about integrity, isn't it?
Very important. And it goes back to the point you made, Rodney, about mentoring. I mean, I've had mentors, I've had barristers, some of whom sadly are not with us anymore. Some are now judges. I've learned so much from them, not just legally, but about everything else, how they do their business, how they speak to people, what you do in certain situations, and mentoring, learning relationships. It's every day. Every day you should be building on that and learning. So
Well, thank
important.
you for that. Well, there you have it, folks. I mean, I think you'll agree that John, I mean, he's gone over a lot of stuff there and some very, very important messages coming out about your relationships, about keeping up with your law, about being empathetic. And I think, John, I want to thank you very much for today. The insights you've given our listeners have been priceless. Thank you so much.
Thank you, Rodney. Take care. My pleasure.